56360. Kay Harrington as petitioner, Kevin Jones as respondent. Petitioner, you may begin whenever you're ready.
Good afternoon.
Good afternoon.
May it please the court, Noah Levine representing the petitioner. This court must reverse the Ninth Circuit's decision to acquit the respondent of his 4 convictions due to the alleged denial of his Fifth Amendment rights. Now, the respondent may argue about the unambiguous nature of his client's exclamation, quote, "I don't want to talk no more, man. You don't want to hear what I'm telling you." The respondent may argue that questioning ought to have ceased immediately following the statement. At the end of the day, it's neither up to me nor this court to determine the intent behind the respondent's statement. This case is solely about the Ninth Circuit Court's misapplication of AEDPA, solely about the misapplication of a clearly established federal statute. Under the Anti-Terrorism and Effective Death Penalty Act of 1996, the Ninth Circuit Court was able to grant relief only if it discovered an unreasonable application of clearly established federal law. Your Honor, the standard set by AEDPA is a high one. Unreasonable application. This means that the Ninth Circuit Court was only lawful in overturning the district court decision if it discovered an application of law that was irrational, that was lacking justification such that there could be no fair-minded disagreement.
Let's look, though, at, for example, the Michigan versus Mosley decision of 1975, in which this court, relying on Miranda, held that when a suspect asserts his right to cut off questioning, the police have to scrupulously honor that request. And so they have to do so, I think the court said, by immediately ceasing the interrogation. Shouldn't this court, implying even AEDPA now, adhere to that prior precedent in Mosley, which was a right to silence case, and find that there was an unreasonable application of that precedent here?
Well, I agree with you in the sense that after a clear invocation of your Fifth Amendment right, questioning must cease. That's a decision given to us by Miranda, and that's a decision that this court should adhere to. However, the lower courts, all the courts in California, up to the district court, believe that this wasn't a completely unambiguous assertion of the right to silence. This wasn't a clear-cut, I'm asserting my Fifth Amendment right, and the questioning went on.
But only in the context of looking at that post-invocation statement did the court so find. And so that seems to be the troubling aspect of this, is that if we don't look at those post-invocation statements, doesn't it appear to be quite a clear statement?
I don't think so. I think in the Smith v. Illinois decision, what we saw was a very clear invocation of Fifth Amendment right, and then we saw a breach of that right and a post-request statement which kind of made the first one ambiguous. This wasn't the case. This wasn't a post-request statement making the first one ambiguous. The first statement on its own was ambiguous.
How so?
"I don't want to talk anymore, man," came after scolding. It came from hours of interrogation where he believed that his side wasn't being listened to, he believed that he wasn't being respected. And so, under duress, under an interrogation, he expressed frustration.
I suppose what troubles me about that is that in any interrogation, there will probably be a suspect whose story isn't being believed in the interrogation that goes on for a certain length of time. And so I'm worried about and wondering if you can address the precedents that we would set if we sort of allow those facts alone to cast doubt on a statement like, "I don't want to talk no more."
Well, I think on one hand, it would certainly be a dangerous precedent to set if we allowed people under interrogation, under custodial interrogation, which you're right is a setting which by nature is intimidating. And so it's understandable that his statement came, and it's understandable that statements would come like this in the future. With that being said, if we are going to look at the precedent at the time, Miranda v. Arizona, what we have is that there needed to be a clear assertion of his Fifth Amendment right. And all of the California courts and the U.S. District Court did not believe this, and more importantly, it was reasonable that they did not believe that it was unambiguous. Now, this case presented a distinct challenge to the lower courts, given how unclear the right to silence procedure was at the time of the original trial. And given this circumstance, the U.S. District Court decision, which the respondent may argue was incorrect, was entirely within reason.
Thank you, Matt.
Good work.
Good afternoon.
Good afternoon.
May it please the court, Michael V. McGeehan on behalf of the respondent Jones. This court should affirm the Ninth Circuit Court decision that Jones unambiguously invoked his right to remain silent under Miranda v. Arizona, and that the state court's use of Jones's subsequent statements after he invoked his right to remain silent was not a harmless error. This court has firmly established that a suspect's custodial interrogation must cease when he invokes his Fifth Amendment rights. The right against self-incrimination is one of the bedrock principles of the U.S. Constitution. Today, I ask that you reaffirm that commitment to the Constitution by suppressing the evidence gathered after Jones invoked his right to remain silent. In the case of Miranda v. Arizona, case decided in this courtroom in 1966, when a suspect in custodial interrogation indicates in any manner that he does not wish to continue to speak, continue to be interrogated, the interrogation must immediately cease. Jones's proclamation that he, quote, did not want to talk no more cannot be misconstrued. Neither can the detective's response of continuing questioning after Jones made that statement.
Let's stop there, because was there really continuing questioning? We have the statement that's made, I don't want to talk no more, man. The next thing said is, I understand that, but the bottom line is, and before that sentence is complete, Jones interrupts with, you don't want to hear what I'm telling you. So there wasn't actually a question posed. So when you say that there was continuing or ongoing interrogation, is that really a fair representation of what happened?
Yes, Your Honor, I do believe that is a fair representation. The main reason is the trial court's initial decision was based entirely on statements Jones made after he issued this statement, I don't want to talk no more. So by that very nature, over the course of the 3-hour interview, all of Jones's statements came in the final 15 minutes after he said those words. In addition, precedent states under Burgess v. Thompson in 2010 that we can now no longer look to statements made after the fact to cast retrospective doubt. The reason that Burgess v. Tompkins is applicable here is because Burgess v. Tompkins allows us to apply Smith v. Illinois in 1984. And in Smith v. Illinois, they found, dealing at the time with the right to an attorney, that you cannot cast retrospective doubt based on statements made after the fact.
If we apply Tompkins to this decision, though, or this case, aren't we doing so in a retroactive manner? And so that troubles me in particular, because how would the trial court have known to look to, for example, a decision like Smith, since it was a right to counsel decision, not a right to silence decision?
Yes, Your Honor. I would argue that Burgess v. Tompkins in 2010 merely clarified existing law. In fact, in many aspects, Burgess v. Tompkins actually weakened Miranda v. Arizona. If we look purely at the standard set in Miranda v. Arizona, when a suspect indicates in any manner, I believe that this broad sweeping language here easily includes Jones' statement, I don't want to talk no more.
So what happens then in instances where a statement of that nature is made and then it's followed up by another statement, maybe not even in response to questioning, that makes the first one sound like it wasn't what it sounded like, if that makes sense? So it sounds like an invocation and there's a follow-up statement that maybe then you think, okay, wait, maybe he wasn't saying that. Are you saying in all instances the officers just have to stop questioning?
Your Honor, to your question, in the United States versus Lafferty, which is a case in the Third Circuit Court of Appeals, they found that the suspect does not need to repeat his request to remain silent. The responsibility is on law enforcement to scrupulously respect that demand. Because the detective responded, I understand that, but there can be no doubt the detectives did not scrupulously respect that demand, and Jones has no constitutional obligation to repeat his initial request to remain silent. In conclusion, the heaviest burden must fall on our law enforcement. The accused need not know the intimate details of our laws in order for them to be protected by them. Thank you.
Thank you.
Thank you.
All
All right, well done.
That was a good round, guys. Thanks. I had a lot of